Hello guys, welcome back to the channel. I am Prakriti and today we are going to discuss that part of our constitution that is called heart of the constitution, that is part 3rd, fundamental rights. By hearing the word rights, one thing must be clear in your head, that certain rights are given to the peoples, but to whom against these rights are given, that is defined under article 12. That defines that these rights are given against the state, and the state includes, in this part, unless the context otherwise requires, the state includes the government and the Parliament of India, and the government and legislature of each of the states, and all or other authorities within the territory of India or under the control of Government of India. It seems very easy, but it is not, because four authorities are given under this state definition. That is, first, Government and Parliament of India; second, government and legislature of each of the states; third, all local; and fourth, other authorities. Government and Parliament of India and government of legislature of each state is very clear, but all the local and other authorities are not very clear. All local authorities definition is given under section 3 clause 31 General Clauses Act, which said that local self government, which includes panchayat, gram panchayat, municipality, all these consist of local authorities. But what consists of other authorities? It is a very disputed part, which is defined under many case laws. That is, with the first case, that is of University of Madras versus Shantabai in the year of 1954. The question was raised that whether Madras University, this University of Madras, is a state or not, because it was established under Madras University Act. So Madras High Court evolved the principle of etiam generis in this case, which includes that solve a puzzle, that book, magazine, notebook, fill in the blanks. So something related to stationery will come into your mind, something related to study. So in this way, University of Madras High Court held that University of Madras is not a state because it has no sovereign authority as Government of and Parliament of India, government and legislature of each of states, and all local authorities have. So University of Madras was not the state according to Madras High Court. It was held in this case, but this principle of etiam generis was declared as not applicable in the case of Ujjamma versus State of UP. This case rejects etiam generis rules. According to Article 12, bodies have no common genders running through them and they can't be placed in single category or any rational basis. It was held in this case. According to Rajasthan Electricity Board versus Mohanlal in the case of 1967, Supreme Court other authorities include all authorities created by constitution or statute on whom powers are confirmed by law. In this case, the state includes those authorities which are created by the constitution or by other statute. They are getting power through law. According to our case Sukhdev Singh versus Bhagat Ram, that is the case of 1975. In this case, the question was raised whether the authorities created by constitution or statute, but for the commercial purpose, whether they are to be included in state or not. So the question was raised that consists of ONGC, LIC, IPC. As decision by Rajasthan Electricity Board, the court held that all these bodies are as created by the state. So in this, the commercial bodies can also be regarded as state. Then with the other case, that is very important, that R.D. Shetty versus International Airport Authority. In this case, instrumentality test was evolved, which consisted that the authorities which have degree of control with the state or extraordinary financial assistance from the government, that is to be considered as state. But in the other case, Som Prakash versus Union of India, in this case, Bharat Petroleum was held as a state and it consists of 5 functions which to be included in instrumentality test. That first, financial resources of state being the chief funding state. Second, functional character being governmental in essence. Third, prior history of the same activity being carried out by the government and made over to the new body. Fourth, plenary control residing in government. Fifth, some elements of authority or command. But in the next case, Ajay Hasya versus Khalid Majid, determining is not a body was formulated under a statute, but determining is test whether it is acting as an instrumentality or agency, then it is considered to be a state. It consists of 6 criteria to be fulfilled for instrumentality test. That is, first, entire share capital is held by government. Second, monopoly status. Third, financial assistance. Fourth, deep and persuasive state control. Fifth, a department of government is transferred to corporation. Sixth, function of the corporation. One thing which must be coming into your mind, that state parliament is state legislature is covered under state. So whether the judiciary is also a state or not, this answer is given in under 2 laws, that is Naresh Sridhar Mirajkar versus State of Maharashtra 1966 and A.R. Antule versus R.K. Nayak 1988. It was held under this case that when the state judiciary, because judiciary is not just functioning as a judicial functions, but other functions are also covered by judiciary. So when it is not acting as a judicial body, then it is to be covered as a state. Thank you so much guys for watching this video. If you like this video, please hit the like button, and for more such videos, please subscribe the channel and hit the bell icon also.